Good afternoon, ladies and gentlemen. Thank you for joining today's Data Privacy Day call. This is Anne-Marie, the moderator, speaking. Your meeting will begin momentarily. And please keep in mind this call is being recorded. Thank you. Good afternoon, ladies and gentlemen. Thank you for joining today's Data Privacy Day call. This is Anne-Marie, your moderator, speaking. Keep in mind today's call is being recorded and the audio file will be available to you. All lines have been muted upon entry to prevent any background disturbance. Thank you for your attention. Your meeting will begin momentarily.
Yes, I did. I'm set. What I would... Probably turn off my phone.
I'd like to welcome everyone and thank you all for attending Data Privacy Day at CMS. Today's event was organized by the CMS Data Guardians. Actually, I think it would be more accurate to say that this event celebrates the Data Guardian program and was organized by the Data Guardian from the Office of Enterprise Information, Celeste Dade-Vinson. I want to take a moment to thank Celeste for being an outstanding Data Guardian and serving as an example to all of us as how seriously we must take our responsibility to respect the confidentiality of the personal information that CMS is responsible for. Thank you, Celeste. And without further ado, it's my honor and pleasure to call on our CMS Chief Information Officer and Director of the Office of Enterprise Information, Dave Nelson, to welcome you.
Thank you, Karen. All right, it's almost standing room only here. That's great. So what's Data Privacy Day? This is happening pretty much all over the country, but it's even an international event or events to create awareness around privacy and about protecting, personal information. But it's a little bit different here at CMS because I think we've really grasped this. We've really made an effort to make it part of our culture, to make it part of how we do our business, and really how we design all of our programs, for that matter. This is a really I've seen many of you in these types of audiences before, and you've heard me talk about the digital age and the types of things that we have to be worried about these days that are different than they were even a few years ago. I mean, we have smartphones, we have appliances, even medical devices, smart cars. All of these things are out there, and the internet's no longer just something we have to worry about on our desktops. All of these things collect different parts of your privacy information, and it follows you wherever you go. So for these reasons, we have to be constantly on the lookout. We have to be suspicious of emails, phone calls. We have to be looking for all the kinds of risks that could apply to the data that we protect for our beneficiaries, for our consumers, our stakeholders. So as part of the Beneficiary Data Program Initiative, CMS has become a record setter. We're really leading the pack in a lot of the federal government agencies today. We are encouraging our staff and our contractors to stop and to think before connecting. The Data Guardians, as Karen mentioned, are really at the forefront of this. This is something innovative, something we did ourselves. It's impossible to manage privacy anymore from a privacy group all by itself. We need those advocates out there among all of the different offices, the different components, really working day to day to look for those opportunities to really help bolster the controls and in the way that we manage the borders around the data that we're protecting, or even just the processes that we run. So with each of the phishing exercises, I know everybody loves the phishing exercises. We do try to train and help and make people aware of what those threats look like. We talk about Andy's set out a goal for us to get to 0 clicks, but really what we're trying to get to is 0 breaches of privacy information. It's not about the exercises, but I think the exercises have also put us in the leading edge of being able to see these kinds of things, because our ability to react to them, the fact that these kinds of real phishing messages are actually reported to us quicker, to the people that can actually do something about it. Everybody's sensitive to them, and we've actually stopped several incidents before they became really critical. So hats off to everybody within CMS for the added diligence that you've given to this. So to support the data guardians, we actually have meetings bi-weekly. We have trainings that we try to set up to help the data guardians become more aware themselves, and so that they can also, as a group, figure out ways to help support the organization better. So I just wanted to say a few words like that. I think it's something for all of us to be really proud of, something we've done well in the last year, and something that we're out in front of a lot of the federal agencies with. So I'd like to thank everybody within CMS for the work that you've done here, but particularly the data guardians for the extra effort and for the work you've done this year in putting us there. So thank you.
Thank you, Dave. For approximately a year now, we have had the benefit of having a distinguished cybersecurity expert as our CMS Chief Information Security Officer and Senior Official for Privacy, Emery Shulak. Emery is also the Director of the Information Security and Privacy Group. Emery has introduced an integrated approach to enterprise-wide security and privacy policy and program to ensure that the agency complies with all of our IT security requirements as well as privacy requirements. It's my honor to call on Emery Shulak to deliver some opening remarks.
I'd like to thank everybody for coming out today or listening online. I really appreciate this attention and focus on data privacy throughout the organization, because it's really making a change. Since we initiated the Beneficiary Data Protection Initiative last summer, I think you see an unprecedented attention by the staff and by the leadership in terms of the value that this rigorous approach to phishing exercises, to conversations, and understanding about where privacy is going. I think that is mirrored in where the federal government is going right now when we look at where OMB is going with having a privacy advocate, where we look and see a focus on doing on high value assets, particularly around high value assets in the federal space under the federal CIO, for what kind of visibility, what kind of reviews we're going to see about that. We're seeing new legislation for information sharing where privacy has a solid piece of participation in that activity. We also see several new initiatives out of OMB around what they'll call the Blue Sky initiatives, which are kind of a spin-off and an elaboration of the cyber sprint that was accomplished last year. But I think, when you look at where we are at CMS this year, it's just really kind of that step ahead. We've completed 19 phishing exercises since last summer across the organization. The last one we had, just a little over 100 people click on the email. So it was a really good success from where we started with several hundred initially. And it continues to, just really keep, the workforce educated. While, it's not necessarily the phishing exercises protecting you from the data loss, but it educates you to make sure that you are more conscious of what you're clicking on, that you're not compromising your equipment, you're not compromising or sharing information unnecessarily. And I think that's just kind of reinforced every other week as we get these messages out. We try to write up, what the value is, the results and the return from those activities. But I just kind of want to reinforce that every single week we find malicious email attacks, thanks to CMS staff reporting them, as well as us looking for them, but CMS staff helping us find these things. We find people pretending to be CMS employees sending emails to CMS employees. We find people sending, very targeted attacks at 2 or 3 individuals. We see very broad attacks against 65 to a couple hundred individuals. And this is happening every single week. This isn't some hypothetical threat. This isn't something, that is out there and affects only other people. It affects every single person. And you might not have gotten one, or you might not have realized you've gotten one. Because we have so many people educated into the process right now, we catch spam phishing messages, we get very directed attacks, we catch them very fast. And honestly, because people are reporting them so quickly, they're often deleted from your mailboxes long before you even see them at this point. And these are activities that, a year ago weren't even happening. So, we look at 100% of the email messages that are reported to the spam mailbox. We do not report to every single person who goes to the mailbox just because it is an overwhelming. We get several hundred a week. But we do look at every single mail message to see if it is a target of attack. And we work on it. And if you were one of the first people who reported one that we determined is malicious, you know, we really are trying to do a better job of reaching out to let you know that you were correct. And it is something that's taking a little bit longer than just, you know, actually blocking and deleting messages. But it's an ongoing activity. So, you know, I think when you look at the Beneficiary Data Protection Initiative, we've got some solid, you know, evidence that this is really helping our risk posture and improving our ability to protect beneficiary data. I think we have a number of other activities that are going along with that, including the new legislation, including the new OMB initiatives that we see. You know, we're going to have speakers today that I really thank for coming out today and really kind of understand how important and how much visibility privacy has at the moment. You know, we spent a lot of time over the last year working with third-party web applications and making sure that we have clearly identified the privacy risks and exposure to our consumers on healthcare.gov and other sites. And we're going to continue working on that. And in fact, we actually have an initiative right now to refresh all of our privacy impact assessments across all of the CMS systems and refresh those and publish those on the HHS website in the near future. And when I say the near future, I mean the next year. We're also looking at our SORNs. We're looking at all different aspects of the privacy program. We're looking at our policies. OMB is looking at revising their policies and their guidance as well. So, you know, you see this coming to a head this year, and we really want to make sure that CMS is positioned to take advantage and really leverage that in our conversation with the consumers and, you know, ensuring that we have the transparency there that they deserve with the information that we hold on their behalf. So I'd really like to thank the privacy team for putting this together. I really know Celeste and Karen put a lot of energy, along with the whole team, to make this happen, and the data guardians who are meeting every other week, as Dave was saying, to move our, you know, our initiatives forward, and then of course, you know, all of our consumers, you know, and on all of our staff who are really, you know, embracing this as we go forward. And of course, and not least, our speakers that are with us today who've really come out of their way in Baltimore in, well, the remnants of a snowstorm to come speak with us. So I really appreciate it. Thanks.
Thank you, Emery. Our first guest speaker, Maya Bernstein, has served as the privacy advocate and senior advisor for privacy policy in the Office of the Secretary of Health and Human Services since 2005. Maya's accomplishments include policy development across the breadth of HHS activities, from policy for health IT, health reform, human subjects research, social welfare, cybersecurity, and personnel. Maya co-chairs the Privacy Working Group of the National Insider Threat Task Force. She represents HHS on the Federal Privacy Council. She chairs the internal HHS Privacy Committee and sits on the National Committee on Vital and Health Statistics, a major advisory committee to the Secretary. Maya's career in the Federal Service also includes positions with OMB and IRS. It's my honor to introduce Maya Bernstein to address us.
Thank you. You can all hear me in the back? I have to get close to the mic, I think. So thank you very much for inviting me to come up here to CMS. I'm not sure I should admit, but I am embarrassed to admit that this is the first time in my over 10-year tenure at HHS that I've been up here. And wow, what an amazing facility you guys have up there. I know, right? I'm like in trouble already. That's not a good way to start. But I'm really glad to be up here and to have the opportunity to meet, you know, many of my colleagues who I've talked to over the phone or met downtown. And it's a pleasure to be here on International Data Privacy Day with my other colleagues here on the panel. We're going to talk from down here because what we talked about doing a little bit in advance is having a little bit of a discussion among us. So I have prepared remarks, but we are hoping that you will. There's a couple mics here that you will ask questions and be engaged with us about what we're going to talk about today. I wanted to talk a little bit about sort of how we got here, the history of the Privacy Act, really, and history of privacy, which is something that this department in particular should be very proud of. And I get the sense when I talk to my colleagues that not everybody knows what that history is and where we came from. So I thought I'd talk a little bit about that and branch off from there about where we are and where we're going next. So the Privacy Act is really so my favorite law, right? I started my federal career at OMB, and I was the lead on oversight of the Privacy Act, so I've been thinking about the Privacy Act for a really long time. So it's passed on December 31st, 1974. That's the date the president signed it. Imagine, on New Year's Eve. President Ford was signing the Privacy Act. And it's a model for many other laws that you might come across, including HIPAA, which I know you guys deal with all the time. But where did that thing come from? Back in the 60s, the government was pursuing a program to gather together all of the statistical data kind of into one central place. And there was a lot of concern, uproar, nervousness about that. And the secretary of then HEW called together an advisory committee to think about what we should do about this. There was kind of a big backlash about, in the same kind of feeling that we get today about other kinds of big gatherings of information that the government might do. And so the secretary of HEW called together an advisory committee on automated personal data systems. And it was there to look at Social Security numbers, mostly, but instead came out with this, what I think is a particularly incredible set of recommendations, which I really believe are some of the most important recommendations that ever came out of an advisory committee, most productive, the ones that actually ended up having the most long-ranging and wide effect on government. And the committee consisted of a range of people. They had consumers, there were academics, there were researchers into, there were computer scientists, there were lawyers, there were ethicists, and some of those people are still around, although we are losing them. Some of the major ones have died in the last few years. And their charge, as I said, was particularly to focus on Social Security numbers, but they expanded their idea about what that could be to something that I think is pretty incredible. They came up with this idea of a code of fair information practice. Nowadays, we talk about the FIPS, Fair Information Practice Principles, which is a term that actually comes out of Homeland Security, so not my favorite way of referring to those principles, but the original HEW recommendation was a code of fair information practice. And that idea was a thoroughly American idea. It was the first time in the whole world that anyone had come together and put these principles into one place in a package. And from there, OECD in 1980 and other entities have come out with other privacy principles, but the original set came out of HEW. And for me, I am frankly very proud of that. And never fail to mention it whenever I get a chance. The original code had a certain kind of principles in it that will seem familiar to you. There should be no secret record-keeping systems. That people should have a right to find out what's in their record and how it's going to be used. That people have a right to prevent data collected for one purpose to be used or disclosed for another purpose without going back to them for their consent. You have a right to correct, or these are all recommendations, correct or amend records about yourself. There is an obligation on the custodian of records to maintain records that are reliable for their intended use and to take precautions against misuse. And that broke down to things that we now have in law, right? That the whole basis of the Privacy Act and of other privacy law that came after that is based on these principles. So the Privacy Act really was the first model of a law that encompassed all these principles. And so you have notice and purpose specification. You're supposed to declare in your system of records notice, which is the way that we have not secret record-keeping systems. We publish in the Federal Register for anyone to read. We have to specify what our purpose is in collecting information. We are not allowed to share information without the consent of the individual, and there are exceptions. And that structure is the same structure for pretty much all privacy laws that we have. There's access and amendment rights, limitation on disclosures with, as I said, certain exceptions. the idea of sharing the minimum necessary to achieve your particular purpose, and standards of quality. So keeping records that are accurate, relevant, timely, and complete to ensure fairness to the people that we're making decisions about. There's proper security and redress as well. So when we look at that, and we look at more modern privacy law, HIPAA, for example, another major privacy law that here at CMS you're very familiar with, obviously. The principles that came out of that original code of fair information practice map pretty neatly onto what we have in HIPAA, but not all of them are there. So for example, we don't have consent, right? We don't have consent to collect in the first place, like you do in the Privacy Act. You have a notice, somebody gives you their data, they got a notice, and they get to decide, based on the notice, that the individual notice that they get on the form or the web or wherever we're collecting the information, based on this notice, do I want to give you the information? We don't really have that in HIPAA. Why? Because, well, you go to your doctor, and you're presenting yourself for examination, and pretty much that's kind of like your implied consent, right? So, and your doctor is going to collect sort of like any kind of person who's doing an investigation, lots of information. They might or might not know what the relevance is at the time that they collected the data. They're going to put together a package and try to figure out a diagnosis about you. So we don't have quality standards in HIPAA. We don't have certain other kinds of things that you have in the Privacy Act for good policy reasons and for the ways that the medical system works. We do have minimum necessary for sharing, but not for collecting, because when you collect information, you don't know what's going to be relevant or necessary at the time you collect it. So when I think about that, and I think about other kinds of privacy laws, and I go back to thinking about that code, I often go back, and I keep a copy of the advisory committee report on my desk. I often go back and look at it and think of it as a checklist for reviewing all kinds of privacy policies that we might work on. So if you've been asked, for example, to design a new privacy program, what kind of elements does it need? How do you know what you're supposed to be doing when you create that privacy program? You go back to that code and you go, oh, I need this part, this part, this part, and this part. Is what I'm doing, if you want to look at, is what I'm doing in my office, and if you leave the government, at your company, at your client, is what they're doing appropriate? Well, I can go back to that code. Have they checked all those boxes? If I'm sharing with a partner, trusted partner, how do I know whether I should trust this partner? Is their program meeting with all these pieces of the code or not? And what pieces are missing? And is there a good policy reason or a good practical reason for some piece of it to be missing? And so I think that code is still very relevant to us today and very helpful in guiding the kind of privacy policy work that we do. So I want to sort of take that and say, well, at HHS, this is something that we began and that's being used all over the world to guide privacy policy efforts. I think I'd like to, so that's sort of how I think about privacy. Moving now, not just to today, our dealings with HIPAA, but thinking about sort of what are the hot topics. I'm just going to name a few off, and hopefully we can have some discussion about some of them. Things that I'm thinking about or we're being asked to think about nowadays in privacy. A lot of it is consumer-created data, so your Fitbits, your wearable technologies, ingestible technologies, right? I've seen a really cool, I got some looks. A really cool demonstration at a privacy meeting of a tiny, tiny, tiny little chip, I guess, that you swallow. FDA has approved this, and you swallow it along with your pill, and you have a little monitor that's taped to your chest over here, and it picks up information from the thing that you swallowed. And it can tell things like what your temperature is, what your blood pressure is, what time you took the pill, how long it's in your body. And it can tell whether you're sitting, standing, or lying down. And sometimes they can tell other things too. And the guy that did the talk, he took one at the beginning of the talk, and then there up on his screen was like, here I've been walking around, here I was sitting and not talking. What is it useful for? Well, if I wanted to, I have a mom who's 83 years old and who lives in Albuquerque, New Mexico. And if my mom were taking a medication, if she gives me permission, she can send that information to her device and send it to my device, and I can know, did my mom take her pill today? Do I have to call to remind her? Did my mom get up at the usual hour that she gets up, or do I have to call and check on her? So it's a way for the patient, or maybe the doctor, if the patient decides to share that information, to monitor and control various kinds of things about their health. Personal health records, we have data cards and home equipment. Some of you may use, like if you have sleep apnea, if you use a CPAP machine, there's a little card in there, sends data to your doctor and to the company that made the machine about your sleep habits. Another big topic is social media. I think you're going to talk a little bit about data in the cloud. We heard Emery talk about security, breach response. Those are really hot topics. And the other one is our personnel stuff. I've been doing a lot of work on personnel, as maybe you've been thinking about that too after the OPM breach. And there are, at a high level in Washington, people are thinking more and more about privacy. So we now have the appointment of Mark Groman, who's a senior advisor to the director of OMB, a political appointee who's bringing a lot of energy and hopefully more resources, more attention to privacy. And if he can get what he wants to get done on his agenda in the next, 6 or 8 months, that'll be good, because by January he's gone, right? So I think we are going to be seeing in our work a lot more attention, hopefully some more resources, at least more policy focus on the importance of privacy in many, many aspects of our work and our personal lives. And I think that's an interesting and positive development. And I look forward to working with you all on that.
Thank you, Maya. I'd like to introduce our next speaker, Rebecca Gwelt. Rebecca is an attorney and partner at the Nixon Law Group. She provides legal, regulatory, and business advice to healthcare clients. She specializes in areas of health law related to ACA reforms, health IT, and HIPAA. She represents healthcare providers, both large and small, and handles matters ranging from compliance and licensing to mergers and acquisitions. But Rebecca is really my role model. She was the architect of the Marketplace Privacy and Security Regulation and worked to establish the security and privacy framework for eligibility and enrollment for the Health Insurance Exchange and Marketplace program. It's my distinct pleasure to introduce Rebecca Gwelt, and I'm going to come down and sit on the panel.
Thank you. Shall I say? Yeah. So Rebecca and I talked, and I promised her she wouldn't have to make really prepared remarks. So we're calling her our discussant.
That's right.
Right.
That's
so
right.
we're going to try to have some back and forth here. But I think Rebecca will have some insights about what's going on outside of government with her clients and the more modern things that she's seeing in the marketplace.
That's right. That's right. And I actually, for a second, want to go back to what Maya discussed first here about how HHS really created the framework that continues to be used to build privacy programs and to evaluate privacy programs, and to sort of give you some background about how I and a team of other CMS employees actually did that back a couple years ago. So I'll be talking about how we built the privacy program based on that framework. So in 2010, not sure the level of knowledge in the room, the president signed a relatively uncontroversial law called the Affordable Care Act. And now that has been smoothly implemented without complaint, I'd like to take a look back sort of on the good old days. I was hired in, started my career at CMS just after the passage of the Affordable Care Act. In the Office of Exchanges, which used to be in the Office of the Secretary, and which became CSIO, the Center for Consumer Information and Insurance Oversight. That's right, I remember. And with a small team of dedicated employees, some of whom are in the room today, including Karen and Celeste and Walter and a number of others. we created the privacy and security program that the health insurance exchanges and their partners had to abide by. The exchanges are quite broad in scope in terms of the information that they collect and the partners with whom they work. My small team worked with the Social Security Administration, the IRS, Department of Treasury, the Department of Homeland Security, state-level folks, the Peace Corps, OPM, the Domestic Policy Council, a huge array of people, including technical folks, policy folks, operational folks, all the way up and down the line across the government to come to an agreement about what privacy should look like for this program, none of which would be possible if we didn't have a set of fair information, or sorry, I'm going to say fair information principles. That's incorrect.
It's okay.
The FIPS.
We
FIPS.
call them the FIPS now.
The FIPS.
I'm
that's
resigned
right.
to it.
That's right. And so we were able to discuss harmonization of the FIPS, HIPAA, which does not apply to the exchanges, but which applies to a lot of the entities with whom they exchange information, including payers and Medicaid agencies. The MARZ-E document, I don't know how many of you are familiar with it, the minimum acceptable risks, the minimum acceptable risk standards for exchanges. That's right. It's been a couple years, so I'm a little bit rusty. But we worked together and we're able, again, to have those conversations about how to harmonize our standards because of what had been created before us. One of the main challenges, aside from working with all of those entities and from harmonizing multiple standards, and working with, quite honestly, having policy folks working with the OIS staff, that was always quite fun. We spoke a different language at some points. The other challenge was really educating leadership about why this was important and what resources we needed to get it done. And it is such a pleasure for me to see that CMS continues to take us seriously, to build programs that respect privacy and security of beneficiary information, but also our information. I got my letter from the OPM breach as well out there in the private sector. I, like you, I'm in private practice now, but I, like you, am often in the position of talking to folks who don't really want to hear what I have to tell them because most of the time it's, no, you can't do that. So I understand the plight of the privacy officer, the data guardian, and I just encourage you to keep at it. That's what we did, and I think we did a pretty good job. And we'll also talk about the new age stuff. But I just wanted to give you a background of how we actually put into practice the things that Maya worked on and how that continues to happen. So thanks for having me.
Thanks, Rebecca. So I'd also like to introduce the third member of our panel. And that
Can you hear
is
Karen in the back?
Can you hear me?
Yeah, you have to pull the mic.
I'm
If you
sorry.
turn your head, you're
Okay.
going to...
I got it. Rosalind McLean. She's a good friend and a colleague. She's an attorney in the HHS Office of the General Counsel and is a member of the Program Review Branch for CMS Division. Rosalind is the subject matter expert for everything data for the Health Insurance Marketplace program, from collection to destruction, security and privacy, and everything in between. Prior to coming to CMS, Rosalind served as in-house counsel for the medical device company Covidian and as counsel in the Healthcare Government Contracts Group at Crowell & Mooring. It's my pleasure to invite Rosalind to join Rebecca and Maya at this roundtable discussion, focusing on data privacy day, the theme of respecting privacy, safeguarding data, and enabling trust.
Thank you, Karen. Thank you guys so much for having me and inviting me. One of the things I like to tell people is that I am having the time of my life here at CMS, and I'd like to talk about how I got here because I believe it stands as a testament to the role that everybody can and does play in privacy. I started off as a children's television lawyer, and I used to spend my time telling people, 3 months ago you played too much commercial matter. during children's television hours. Most boring thing I've ever done. I decided I wanted to litigate. So I found this small healthcare litigation boutique that was willing to take a chance on a second-year associate that had no lit experience. And it was the best move I could have ever made. We were a full-service firm, but we did all things for healthcare clients. So there is where I kind of became a healthcare and government contracts lawyer. Because we had such a good thing going, we got bought out by one of the big guys, and I went there and started working with some of the contractors that were working on some of the most sensitive government projects, from shipbuilding to satellites to airplane building to military supports. I learned about CODIS radios. And there is where I had the opportunity to convince people that there was a viable intersection between healthcare and government contracting. People kind of saw it as separate. What CMS did wasn't your usual government contract. It was just different. And so I kind of got to pave my own way. And in 2006, they said, Raj, what are you interested in? What do you want to do? And I said, I just read this article on cloud computing. And they said, cloud computing? Nah, we don't think there's anywhere to go with that. So I said, okay, but I kept watching it. In 2009, AHLA was looking for somebody to talk about the HITECH Act. So I wrote a little article on HITECH and what that meant. And because I was ready to get out of this place, an opening came up in the Office of General Counsel of HHS to support the Office of the National Coordinator for Health IT. And when I went to the interview, they were like, you're the only one that's ever written anything on this. And I got the job. Due to a family issue, I had to leave shortly after that, but after all of that was over, I went in-house for a while. I came back after the Affordable Care Act was passed because I wanted to work on this program. And now I work on a program that OMB refers to its signature website, healthcare.gov, as the gold standard for government websites. And I hope all of you guys know that you all play a part in that, and that you do have that label on you, and that everybody's watching this website, and that there are teams that are doing such a great job fulfilling the goals that healthcare.gov is supposed to fulfill, and is taking it even farther. One of the things that I love about my job is that I have my own triage unit, and that's you guys. To have a privacy group that is the first line of defense for privacy issues is very important to a lawyer, because as a lawyer, you can't know everything. All the people that you're required to serve, you have to kind of learn what their work is with every different project. So I would say that I learn something new at least 3 days a week. I get to throw around jargon like vectors of attack, and people think I know what I'm talking about. So it's such an interesting field. You guys play such an important role. We're doing such great work. We are learning from the mistakes that other agencies are making. We're listening when people say you should be concerned about this. We're reacting, and we're being proactive. And that's all because of the work that you're doing. When Karen told me what the data guardians were, I was like, oh, that's cool. That's interesting to have somebody in every office who's looking at this and who's concerned about this is, to me, just a testament of how seriously this agency is taking this subject matter. And I thoroughly enjoy my job. I thoroughly respect the work and the tenacity of the CMS Privacy Office. And it's a pleasure to do this work every day.
Thanks, Rajlan. So for me, it's a real honor to be sitting here with the three of you. Each of you have really distinguished yourselves in different ways. as forward-thinking advocates for protecting the individual privacy interests of the people whose information you come across in your work. Although I've only heard and read about some of the work that Maya's done as a privacy advocate, I look forward to the opportunities that I have to work with you. I cut my teeth with Rebecca. She taught me, she challenged me, she inspired me when I first came to CMS. And Rajlan, I feel like we share a privacy soul. There's hardly a day that goes by that we don't we tag team on some highly charged issue and that somehow implicates the use or disclosure of personal information. And the four of us could probably talk shop all day long and not tire of it at all. But I'd like to ask you some questions so that we can engage you, the audience, in our conversation, and hopefully light some fires and get everyone that's listening today to the Data Privacy Day presentation to think about what it means to respect privacy, what we think are some of the most important steps to take to safeguard data, and what strategies we should consider to make sure that the people who give us the personal information feel comfortable doing so. In other words, to make sure that they trust us. So, as experts dedicated to protecting the privacy of personal information, one of the things that always surprises me is that so many times people that come to us for advice or guidance think that there's something complicated, or they have this huge question like, how does privacy work? And there doesn't seem to be one single answer that contributes to this, but some of the things that stand out in my mind are that one of the reasons is that it seems so esoteric, is that privacy is a real personal matter. So what might be super private to one person is no big deal to the next guy. And we see that on Facebook, we see that in the social media that people interact with. Some people just tell it all, and some people don't even have Facebook accounts. So that's one sort of conundrum in this. And that's at a personal level. At an organizational level, whether the entity or the organization we're talking about is the federal government or a private company that might collect personal information, that organization has to let their employees use the data that they're collecting for conducting their business. And they also have to share that information, or usually have to share that information outside of their organization so that they can do their business. And that seems to always create this worry that, what's going to happen. So the first question I'd like to pose to the three of you is, when collecting personal information from consumers or from customers, what are some of the things that organizations should consider?
So I'm the sort of token private sector person here now that I've, flown the coop. What Karen said is absolute. First of all, let me say I'm excited to geek out with you privacy folks today. I don't get many chances. What I would say from a private sector perspective is, what Karen said is absolutely true. This is about building trust with your customers. And some of my clients' customers are healthcare providers, and some of my clients' customers are us, right? They're doctors, and their clients are the patients. And so, one of the most important things you can do is be really transparent and thoughtful about what you're going to do with the information that you're collecting. It sounds very simple, but the reality is these are business owners, and they're there to do their business and collect their fee, right? And that has to do with what the substance of their business is, not with the what they consider the sort of technical aspects of collecting information. And so what I tell them, aside from obviously complying with the law, but what I tell them is the responsibility that you have to protect this information is quite a serious one, and your business future, your financial future, depends on you taking it seriously. There are studies that show that, for instance, a healthcare provider that has a data breach, whether it's their fault or not, has a data breach, 30% of the patients of that physician leave or say they would leave. That's a big deal. That's a big deal even if 10% of your patients leave. That's the end of your business, and it's hard to recover from that. And the way that you guard against that in the environment that we live in, which is there's nothing that you can do to absolutely prevent your staff from accidentally leaving a thumb drive in their car, or your laptop from being stolen from your car, something like. I mean, this is what happens, right? There's nothing you can do as a business owner to prevent that from happening. But what you can do is be very transparent about what you're going to do with that information, and give your customers the opportunity to say, yeah, that's okay with me, or no, that's not. So I guess that would be my response.
I would add that when I talk to people who are starting a new program or are thinking about collecting information for the first time, I like to ask them to consider the whole life cycle of the data, not just when they're collected, what's their authority to collect it, but think about what's going to happen to that data throughout its entire life cycle. Who's the audience for this data? What is the mission need for it? Where's your authority? Am I going to want to disclose it later on? And what disclosures am I going to want to make? So trying to anticipate, and this is the hard thing. I think it seems easy, but trying to anticipate all the different kinds of needs or desires for the data once you have it, and really thinking about, should I be collecting this data in the first place? Aside from whether I have the authority, is it a good idea? If it fits within my mission, is it really necessary? Can I do with something else? Can I collect it in a way that's less identifiable? Can I get the job done without actually risking people's identity? And so thinking about other alternatives. What are the limitations on the data once I collect it? Am I collecting it under a license? Have I bought it? There's different ways that we get information. We get it through regulatory means. We get it voluntarily. People send us data. We sometimes buy data. Sometimes we create our own data out of analytics that we do on the masses of data that CMS has, for example.
Yeah, and I would just add the challenge that she's sort of getting at here. The challenge to do what it is that you're saying is getting more complicated as covered entities and business associates are integrating multiple different technologies that all have information flying in and out of them. So it seems very simple, from a policy perspective, to tell someone, figure out what's going to happen in the life cycle of your data. A lot of clients that I work with don't even know where their data is. They don't know. They don't have an inventory. They have no idea. They have no inventory. They don't understand that a software program replicates data that's sitting in their server, and those are two different things they need to consider. So as they, I can have the conversation with them about the life cycle of the data, but the reality is they've also got to take stock of where it is in their system, right. And so that's not always apparent. They don't even know if the
data they're about to collect is duplicating data that they already have.
They have no idea.
Right?
No.
So for us, if it's duplicating data we already have, we're in violation of the Paperwork Reduction Act, right? But for them, it's a business expense that maybe they could have avoided. Mm-hmm. So there are different ways of thinking about it, whether you're inside government or not, but I think the same principles apply. And I don't want to minimize how difficult it is to anticipate what it is you're going to do with the data. So, when I came to HHS 10 years ago, I thought, well, this is going to be so great. Here's an agency that's quite sophisticated, that has, well-trained people and actual practitioners and, real experts in privacy in particular all across the department. And they really understand privacy. They got medical records. They got lots of welfare records and so forth. It's going to be great. And when I came over here, what do I find? That's all true. But what's also true is the department, anyone in the department never met a datum they didn't want or love. It's a big research institution. They love data here, right? They want to collect and hold on to everything because we might think of something to do with it one day, right?
Walter knows this well.
Right? Right? We might think of something to do with it one day. And it's like, that's not really the way you're supposed to think about these things, right? Do I have a mission for it today? Can I figure out what I'm going to do with it tomorrow? And down the road, if I think of something else, well, maybe that's too far removed. But that's a very difficult tension that I'm sure that you feel here. I feel it downtown too. That we love data, And that's a challenge for privacy people.
Right, and I think that, to bring what Rajlan and I do into the conversation, we deal a lot with this fledgling program that really didn't necessarily think through everything that they either need to do or want to do with the data that they have. So we get those questions, okay, now we thought of something different or something new, and we have to come up with sort of creative ways to let it happen. So I think Rajlan can speak to that.
Right, and well, I'll start at your original question, like what you guys should be thinking about when you are thinking about collecting data. And in addition to thinking about the life cycle of the data, one of the things you have to do when you're dealing with data is be very organized in your thinking. Write things down, write an outline down. Think about the life cycle, and then give yourself some time to channel your inner deviant. Channel your inner criminal.
I love it.
And think about all the things that could be done with this data, all the things that could go wrong, all the things that you could do with it to make a little change. Think about those things, because that's what's going to lead you to say, okay, what type of limitations do I need to put on my contractors when I give them access to this data? Do I really want to collect that? Because if I lose it, that could be really devastating. And is the risk of collecting it worth the risk of something going wrong? These are all the types of things that if you think about first, you'll find that formulating your program is a lot easier. You'll find that the overreach is lessened, potentially. And you'll find that at the end of the day, people aren't telling you, no, don't do this, because you've kind of already cut those things out. It is challenging when you have a new program, because you have all of this data that you're not used to having. One of the things that we always see is when we're doing our contracts, like Rebecca explained, the exchanges are not HIPAA-covered entity. But you're going to see a HIPAA provision in a lot of exchange contracts, because we're CMS, it's all about HIPAA. But now with the exchanges, we have to think about more than HIPAA. We have to think about Section 1411G, and if you guys know about Section 1411G of the Affordable Care Act, after I leave here, I will consider myself a success. Because it's, it's...
Tell us all about it.
I must know.
Well, let me tell you what 1411G says. 1411G says that basically when a consumer is applying for health coverage through an exchange, the recipient of that data may only use or disclose that data for a purpose that fulfills the efficient operation of the exchange.
Do you remember that?
I knew.
Yes.
I knew that one.
And the great thing is you guys are who defines what the efficient operations of an exchange means. And it's something that is fluid, something we're still defining. But that means that where other agencies have been used to coming to CMS, because CMS deals with HIPAA and there's so much law on it, there's so much guidance, there's so many people out there speaking about it. There's nothing about HIPAA that you can't find somebody having discussed before. So agencies are like, oh, the exchanges, they have all this data, let me go get some of it. And we're like, FBI, no DOJ.
Yeah.
And that's
Doesn't go over
very
very
uncomfortable, because they want to know, why can't I have this data? We're DOJ. Why can't I have this data? Because I want to investigate these persons for violating 26 U.S. Code something, because it has nothing to do with the exchange. And this administration has been very clear that they want consumers to feel very, very comfortable coming to get health insurance. They don't want to have to worry about ICE knocking on their door. They don't want to have to worry about the IRS knocking on their door for some reason because they gave their information to the exchange so their child could go to the doctor. And I think that was a bold move on the part of Congress. And they don't make many bold moves. So that's one of the things, as you're thinking about this, just think about the new ground that CMS is charting with the exchange work, even with some of the work that it's doing in the research arena, because there's just so much opportunity with data. There's so many smart people out there figuring out what I could do with this and what I could do with that and how I could put it together to do this, that, or the third. So it allows for a little bit of detective work. And the great thing about privacy, you know, if you're a doctor, Google doesn't do much for you. If you are an engineer, you know, it might be a little dangerous for you to go out on Google. Great thing about privacy, Google is great. If you want to see how something could go wrong, Google it. It is out there. So it's so much fun. One of the things that we always joke about is, okay, how do I talk about privacy and keep people engaged for longer than 23 seconds? And that's why when you go to these types of talks, people are always telling you about the horror stories, because that's what's sexy. That's what, you know, gets people interested, but it's exactly what we're trying to avoid. Right. So I think it's great that you guys have chosen to, you know, build your careers in this field. And when you're thinking about the data that you are accepting, I guess my message is think about what could go wrong.
Right. So some of the tools that we have to make sure that things don't go wrong are notices. So we put a lot of energy and a lot of effort this past year.
Can you talk directly?
Oh, I'm sorry. So we put a lot of energy and a lot of effort into updating and working on our notices. So can we talk a little bit about that, about what it means to tell people and to be transparent with people?
I already talked. Yes,
Okay.
yes. It's very important. For me, it's a very nuts and bolts thing, right? You do the HIPAA breach analysis, and you figure out whether you have to. Private sector does not want to inform you of breaches. I mean, that's the reality, right? It's bad for their business. We just saw Centene Corporation lost 1 million records. They have no idea where they are, but they had to tell you about it, and that's why HIPAA is important, right? A business owner, it does nothing for them to tell you what happened with your data, you know, what CMS and what HHS has put together to force them to do so it's quite important. As a consumer, it's quite important.
Did you mean the breach notices, or did you mean upfront notices, or what kind of notices?
Upfront notices. Like
Yeah.
I'm sorry.
No, but that's okay.
Well, then I point to my first response about transparency.
I mean, I have. How many people actually read the notices that come when they go to the doctor's office? You actually read the HIPAA notice? Like half of you, right? I read the HIPAA notice. Then
I bet you, Rebecca,
I
you
edit
tell them
it.
that they have to change
I
it.
edit it, right? I edit it. I go talk to them and I go, you don't know what I do for a living, but I'm going to tell you.
Actually,
After
if
my
you ever
appointment.
want to be treated really nicely at a doctor's office, tell them you're a healthcare lawyer. It really freaks them out.
It goes over almost as well
You
as
can
a
tell them
medical
you're the
malpractice
privacy
attorney.
advocate. HHS. That works too. They be sure not to mess up HIPAA in front of you. But yeah, I usually mark it. I have a doctor who I go in there like once a month, and they have the same notice every time, and it says, we can share your data with anyone at any time. Please sign here. I'm like, yeah, I'm not signing that. I just cross it out. I urge you to do the same.
They, by the way, should not have that in there either, because that's a violation.
Exactly. So, but here's the thing. I think, you know, at the same time that I think transparency and notice about what they're going to do is important, and that's, you know, one of the basic things in any privacy law, I also think it's really hard to get the notice right. It's really hard to write it at a level that's going to be appropriate for all the possible audiences that a particular business or doctor may have. And we have a lot of challenges with that. That's why people don't read the notice, because it's long and involved, and some lawyer wrote it, and there's, 20 synonyms for every word. I'm sorry, we're all lawyers up here. So we're all lawyers up here. I'm just not practicing law. But it's often written to cover
Cover our bases.
behind of the lawyer and of the business, and not written to really be transparent.
Right.
And I think that's a frustration that we all come across, and it's very difficult to get that right. So we're still working on that. It's iteratively, it gets better, but you know, I think the more that those of us who actually do this work read it and mark it up, you know, every now and then that gives the doctor a little, oh. Anyway.
My little doctor story is that I go in and the little place where they take your blood pressure and your weight, they have computer screens. And I'm like, you know I shouldn't be able to see that, right?
Oh yeah, I do that too.
Yeah.
It's like, see that person's record? I just walk up and turn it over. Yeah. And they look at me like, oh.
Yeah. So when we talk about the notices, you know, we think about, you know, the privacy notice that is on CMS's website or is on the Exchange website. And our goal is clarity, simplicity, plain language. It is hard. But we go through the exercise, and it takes more than lawyers to get it right. Here at CMS, working on privacy policies here, you're going to have privacy people, you'll have security people, lawyers, communications professionals, people from the program, and all of these people working on this one document to make sure it's not too long, to make sure it's not too daunting, and to make sure it's accurate. It's so easy to be misleading and accurate when you're talking about what is and what isn't happening to consumers' data. And it's beginning just to take a whole village to get these things right. And I myself am glad that the lawyers don't have to start the process anymore. We're usually taking something that someone else is writing and making sure all the bases are covered, making sure we're not leaving anything out, and making sure it's updated when necessary. What do we call it, an iterative process?
Definitely.
It's like, this is Karen saying, a privacy policy is a living document. We should have t-shirts made. So that's the thing with these notices, with the privacy policies, and then you add on top of that, with us being a government agency, the Privacy Act statement, because many people don't know the difference between a Privacy Act statement and a privacy policy. I don't think that I knew the difference before I came here. So there's so many things that are special about being a government agency dealing with consumer data. And it often means that we have constraints on us that people in the private sector do not have. But it also means that we have a better roadmap to getting it right. And I think that's all I have to say on notices.
Okay, so I think that you know, what Raj is hitting on is exactly what one of the real purposes of the Data Guardian program is, and what we really want to capitalize on, having data guardians entrenched in every office and in every component. And that is to have a place to ask a question. When I came to CMS a few years ago, I didn't even know what the Privacy Act was. There are really no...
Where did you come from?
The private sector.
So young.
Right? I mean, lawyers out in the private sector just don't make a living off of the Privacy Act.
No.
It's really you know, something that is purely a federal agency, you know, has a federal agency application, even though there is a private cause of action in the Privacy Act. I think it's like, you know, it just doesn't happen that people...
It's very, very hard to bring a case under the Privacy Act.
So when I came, I knew nothing about it. And one of the things that made working with the Privacy Office, which was in OESS when I came, but now it's in OEI, what made it so special was that there were people there, like Walter and Amy and Celeste and Mike, and I could ask them really stupid questions, and they didn't look at me like cross-eyed. So what you should really look to your data guardian in your components and in your offices for is to ask those questions. Because none of the questions that we ask about the confidentiality of the information that we're in charge of protecting is a stupid question. It's just a matter of understanding where your question fits into the framework. And when you ask those questions, then the rest of us can help you do what it is that you need to do in order to either fix something that might be broken or do something that needs to get done. And it gives us the opportunity to tap into what's going on in your components and in your offices so that we can all be compliant. So, I'm sorry.
Well, I was going to jump off on what you were saying. When I started my career, I was saying at OMB, and I was the Privacy Act person. So I was catching all these calls. I wasn't an attorney at the time, but I was catching all these calls from attorneys across the government who asked me kind of two different kinds of questions. How do I disclose what I know I'm supposed to withhold, and how do I withhold what I know I'm supposed to disclose? But what I got, what was interesting to me, and I think what the data guardians will be there for, is you get the questions that somebody couldn't figure out on their own, and so you get the more interesting questions. And the Privacy Act, as I was saying, was passed in 1974. It has not really been updated since then. So now, it contemplated, we have this concept of a system of records. A system of records, where you have to retrieve the information by the identifier or it doesn't count. Like, what is that? That's a file drawer with an alphabetical list of records. Or a numerical list of social security numbers. That's not what we have now. What we have now is electronic databases and full text searching and big data and analytics and all these things that were not anticipated by the Privacy Act. And frankly, even HIPAA, which, was passed in '96, the rule came along a little bit later, it was effective in 2003, whatever it is. Now
HIPAA doesn't know what the cloud is.
Yeah, HIPAA doesn't know what the cloud is.
No idea.
Right? We didn't anticipate rules for how to store things off-site or wearable technology or consumer-created data, and what happens when I literally came from my annual physical this morning. What happens when I don't have one, but what happens if I walk in with my Fitbit and give it to my doctor and say, yeah, add this to my chart, right? There's an issue of provenance and how trustworthy is that data? Is that the same as any other data that I report to my doctor in my physical? How does she handle it? Does my insurance company take it into account or not? Is my insurance company allowed to go out and say, you must if you have a Fitbit? Send me your data from your Fitbit? What about, how I'm driving today? What about the computer in my car?
Yeah.
That says you're driving too fast, or we have a little thing that says you're not wearing your seatbelt. I don't know what's the next technology could be, and how it's going to be used. And I think, so, those kinds of things we're going to be called upon to think about and to make policy about eventually, or very, very soon. These are the things that I know that Mark Roman, the new advisor for privacy at OMB, is thinking about, and I'm sure that you're seeing this kind of stuff in your practice.
Yeah, absolutely. I think the other thing I would add to that list is the changing nature of being a healthcare insurance company, which CMS is, a very large healthcare insurance company, and how insurance and the provision of care are overlapping. And so, in general, according to HIPAA, the insurance companies do one thing and the doctors do another thing, and they share some rules, but really, they do separate things. Now we're entering an era where your insurance company buys you an iPad so that you can see your physician, and coordinates the exchange of medical records between that physician and that insurance company, right? You've got United and a bunch of other companies doing telemedicine, right? That's really blurring the lines between payer and provider. And so not only do you have to figure out how to apply privacy principles to that interaction, you've got to get two people who have two separate businesses and two, bosses and two different worlds to agree on what they're going to do with this information. You're also seeing providers themselves start to become risk-bearing entities. So providers who have a huge amount of medical information, who know what to do with medical records, get into the business of insuring people, and they have to figure out how that changes. How they've got data records here that are billing and the traditional way we think of as medical records, so healthcare information. But now they've got this whole other data store, very, very complex sort of set of technologies that are all interacting. It gets complicated. There's got to be a lot of thinking done about how to update how the government looks at entities like that. That's not completely, by the way, handicapping their ability to innovate, which I think a lot of the private sector has a concern about.
Well, I think the other thing that strikes me as you're talking that I know from my small little doctor's office is, what are they going to get paid to do that's electronic, right? So I send an email to my doctor. She spends some time responding to that email. You know, even if it's all done under HIPAA, can she bill for that time? You know, does she bill for when she calls me back and spends some time on the phone explaining some lab results? Sorta. Maybe that's contained in the, in the actual appointment I just had. But if we're going to ask our doctors to be more available to us electronically and to respond over email to do other things, we've also got issues about and here we are, the people who have a really big footprint in the market for how we bill and how we charge. Medicare, controls kind of a lot of those rules. So are we going to have a way to bill for that?
I
yes,
think
please.
you just walked into the ICD-10 room.
Yeah, right? I did, right? So, and that's not my expertise at all, but right, we've been thinking about these kinds of things and how you bill for them and what's fair for a physician and how they get information and how they disclose information to a patient. So now we're in between the relationship between the patient and the doctor. The security rule talks about...
Yeah, well, I was going to say the security rule. So Maya and I were talking about how, we're morphing to a lot more attention on the security rule. And the unfortunate thing is most providers in this country, payers, it's all electronic, but most providers in this country don't know anything about security. They're not tech, they're not IT
small
people.
Providers, yeah.
They have no idea.
They want to heal you.
Yeah,
they don't want to do your IT security.
It's very difficult for them to comply, especially because now they're being encouraged to do a lot of creative things with technology. In addition to just traditionally keeping information in an EMR, they're encouraged to bring on a data analytics provider, and they're encouraged to have specialized equipment that stores a lot of information. And so that's presenting an additional challenge. Beyond that, the way of high tech wanted everybody to get electronic medical records. Now everything's going into the cloud, and so I know a colleague of mine from Adam Green has been doing a lot of work on the Healthcare Cloud Coalition to try to talk with the government about what it means for the cloud. Right? There's this feeling that the cloud is very unsafe. I would dispute that. I think the cloud is. There's a lot of ways to make the cloud safe, but HIPAA doesn't know what the cloud is, and these cloud providers who are attempting to innovate and attempting to provide a service that actually is very helpful to providers who don't want to keep their servers on site or don't want to rent out a server somewhere else. That a lot of providers when they seek cloud services have to use servers that are in different states, and they don't know what the rules are there. And anyway, it's quite complicated, and I think sort of figuring out, providing some assurance to folks who are trying to offer products that could help providers and payers, but payers, they've got plenty of money. Sorry, they have plenty of money. Helping providers.
The big payers.
Well, you have to have a good amount of money to even be a payer. I mean, that's the reality, right?
The payers have money, yeah.
But
for
providers, to provide some assurance to their vendors who are trying to make their jobs easier and their practices more secure is going to take a lot of sort of working out the nuts and bolts of data privacy for the new age.
I think one thing that's interesting about the work that you guys do is that you're the Centers for Medicare and Medicaid Services. So that means that you're often working with people who are over 65 and don't know anything about the cloud. They haven't set up their, Medicare account under the portal, which causes a lot of issues and for the agency as you're seeking to fulfill your requirements under statute. For instance, the exchanges must send notices to every Medicare beneficiary. And it would be really nice if we could say, well, you know what, we'll make that available through their Medicare.gov account. And that's going to help us meet our requirement. But there are just many people who don't have that yet. Which means that one of the challenges that CMS looks at is, okay, who do these people often work with? whether it be a family member. So how do we work with people and authorize people to be able to work on their behalf? Does that mean that they have to sign a document and scan it into me? And oh my God, where are we going to find the FTEs to handle that? And where are we going to put it? And how long are we going to keep it? And what happens when we can't find it? So there's so many facets to what you do. And then you look at the Medicaid side when you are serving children, many who are in the foster care system, or who are otherwise in some other type of facility, and the ways that you guys are just duty bound to work with people who aren't the owners of the private information that you're dealing with. There's so many hurdles that you guys work your way around, and there's so many more to come. And there's so much room for innovation in how to get it done. I think about when they talk about telemedicine, it's not just the content of the information you're talking about, but when you are in front of a webcam, what can they do with your image? It's so exciting to me, which is why I'm glad I'm here nerding it up with y'all. So it's very interesting, but I really respect the work that you do, because again, people don't think, they think about privacy as just don't let anybody steal it. And it's so much more than that, and we have so much more work to do. So I love it when I get issues and we're just able to kind of play off of each other and think about things. And I hope that the conversations just continue to be more fulsome and people ask more questions, because that is the way that we get our programs right, is when people ask questions and you're not in any way shunned or punished because you asked a hard question.
So with that, I'd like to open up the mics and the floor to anyone who has questions for the panel or for us today. I don't know if there are any questions.
What do you? Can you? You can't.
Okay.
They're going to have to email their questions to the privacy mailbox.
So.
Because of the high volume of participants, the lines are, it's the poor quality of the lines.
What's the address?
privacy@cms.hhs.gov.
If you have questions, you folks on the phone, send them to privacy@cms.hhs.gov. One of the things I thought would be interesting to talk about today, just based on my perspective in CMS, is the challenges that the data privacy staff have in getting questions to the right people and getting their agenda sort of heard by leadership. Again, a lot of what CMS does is actually delivering services and running the insurance company. And what I found was, because of the excitement, because of politics, because of everything that was going on during the setup of the exchanges, it was very sexy to talk about how people are applying and how they're going to get paid and how do they get their tax credits, and how are we going to integrate the insurance information into the CMS systems, and all of that was very exciting to talk about. I was not always the most popular person in the meeting when I said, yes, that's so great, but think about the volume of information you're pulling in and how bad it could be if we didn't handle that responsibly. And it was a challenge, and I just wanted to sort of bring that up and maybe have Karen's perspective and Rojalind's perspective now in the 2 years after I left, to talk about perhaps what challenges you all have and how we might be able to get around it, so that there can be the open discussion and we can move this forward in the way that we need to. I think it's great that at the secretary's level, there's somebody that's going to be talking about this and championing it. I don't think there was anything like that when I was here. I wish there had been.
You want to say something about the marketplace program and where it is now, where we've arrived?
I mean, maybe I'm wrong. Maybe the people in the audience aren't finding that to be the case, but it was certainly a challenge while I was here.
Well, it gets to a point, because what we're doing and what CMS is doing with the exchange programs is so in the news. It's, it's what congressmen are focusing on. And there's just so much energy around it, and it's so important. It's so important. Sometimes I can't believe when we're listening to the policy fights, on television with the people in Congress. I was like, they do realize that we're just letting people go to the doctor, right? You would think we're handing out gold chips or something. It's something that I think, again, as a privacy professional, you may not be the most popular person as far as people expecting to always come to you and you be the yes person. But I challenge you that many times you can be the yes person.
Yeah.
It's figuring out how to get at things the right way. Many times there are just so few areas where it just has to be a blanket no. It's about leading people to see how they can fulfill their ultimate goal, and not totally abandon their project because there's this privacy consideration or this obscure privacy provision in a law. And that's what I found as far as working on the exchanges. Again, when we work on privacy issues, there's so many people around the table that are not privacy professionals. But at the end of the day, we all have to meet in the same place because everybody has to get up from that table at least somewhat happy. But that usually always means that everybody is also somewhat not happy.
Not happy. Well, and the other thing is...
I agree with that. I think that's absolutely a very important point. You want to get to the point where you can say, yes, but you would have to do it this way. The problem is, and I think it's cultural in all organizations, I'm not just picking on CMS. The problem is the folks that are driving things forward in the way that we do, the way that we I don't work here anymore. The way that you
can come back,
In the way that you do, decisions get made like this, and people don't think to ask the privacy person. And so
a
lot of times,
telework even.
Yeah. Oh my God. No. But what happens is that, we have to start when we talk about things that have to do with the exchange of health information or sensitive information of any kind, we have to start making sure we have a seat at the table, right? And I think that's what you guys are starting to do. But when I say the conversations I had about you can't do that, these were points at which the decision had been made and the contract had been signed, and I said, oh.
Well, and that's a huge difference.
Yeah.
That really is. I mean,
but that was in the chaos of what was going on at that time. Yeah, I mean, it was.
I think back, Rebecca and I really did not have a seat at the table.
Right.
I mean, we were. Oh boy. I mean, there were some people that
But we had each other, Karen.
Yes, we did.
We had
we
each other.
definitely did. But there were people in meetings that would flail their arms at us and say,
"Shut your mouth.
Why are you so difficult?" Yeah. And we hadn't said anything. We were just sitting there. And, and it was really a difficult time. But we do have a seat at the table now. And I think that, he had to leave, but Dave spent a significant amount of time here. He spent so much time dedicated to the Data Guardian program. Emory is completely supportive of everything that we do in the privacy office. And so it's really, it's almost a really different landscape that we look at. And
that's great.
So it is different. I could tell you one thing. Remember that Hicks SORN that we wrote?
Okay.
It was a good idea to have it all in one SORN. It worked. It really did.
Good.
And that's the thing. When we were working together, it was like we were groping in the dark. We had no idea what this was all about. But I think that what the big challenge that Rosalind and I are facing now is that now we're able to look and see what's happening to the health insurance marketplace. And that's a really big deal. So it's not just the role that CMS plays, because CMS plays a hugely significant role with respect to healthcare dollars across the nation. So if we think about it in terms of dollars and in terms of the economy, healthcare accounts for somewhere between 22 and 24% of the gross domestic product. That means 23 plus cents for every dollar that's spent in this country is somehow related to healthcare. And at least half of that comes out of this building, or is okayed, or it's managed through this building. So it's hugely important. And it gets back to like why so many of our systems are labeled high value assets and all that kind of stuff. So we're really, the way that health insurance and the healthcare marketplaces function really has an impact on that. So just to get, to sort of give some closure to that question that you've put out there, Rebecca, that's what it looks like.
Yeah, and to bring it full circle, right? I mean, the reason that we can do all this is that framework, right? We keep going back to that, framework. I mean, that's, it can still guide. I mean, when Maya was telling me about this, I had no idea that this had come out of HHS, and it is actually something to be proud of.
Yeah.
I mean, it's something to be quite proud of that we as an organization, formerly me, of HHS and CMS created what the world looks to as their standards for privacy, and so it's a great responsibility to sort of carry that on.
Yeah, so we have one. I'm sorry, but we're getting close to time, and we have one last person that we need to call on, and that is one of our data guardians. One of our data guardians has graciously offered to give us a few words about what it's like to be a data guardian. Jason Vollmer, he's going to deliver some closing remarks. Jason is the Director of the Division of Quality Assurance and Technology in the Office of Acquisition and Grants Management. Like most of our data guardians, Jason has not missed the beat, taking up the responsibility of being OIGM's data guardian. Jason has generously agreed to share some of his thoughts about the program and how it has been received by CMS staff. Thanks, Jason.
Thanks, Karen. So I like the way you put that as, like I volunteered and jumped up and down, but no, with all due seriousness, I appreciated the opportunity just to kind of just share, for a couple minutes, some of the experiences that I've had as a data guardian for CMS, and just sort of some of the, I guess you could say, tales from the data guardian's perspective on some of what we have encountered. So first and foremost, just to kind of speak to our role and how it sits with the Beneficiary Data Protection Initiative. Just understanding that it's a program that we're sort of there for, I guess you could say, sort of boots on the ground. Sort of the first responders, if you will, to sit there and talk to our components or our offices, sort of on the messages or what we're seeing from the actual component level. And just the reception that we're getting from senior leadership, and just for really driving the importance for the program and for what we're trying to actually accomplish. And just to kind of emulate a couple points that have been talked about from the panel level, as well as what Dave was speaking to earlier, and Emery, I think Dave specifically said we're leading the pack, and I think that's actually twofold. When he said that, he's absolutely correct. From the fact of how we at CMS are sort of spearheading the whole issue, taking the bull by the horns per se, but I think the reason we're doing that is really with the understanding of the amount of data that we actually have. I don't know if a lot of people really understand the amount of records in comparison to most government agencies that CMS actually has. I mean, we store, between all the very important programs that we actually do serve, over 100 million records. And I mean, in comparison to the OPM breach, you have the IRS breach, and the recent Anthem breach. I mean, almost all of them combined equals 100 million records in itself. So just really that understanding from our perspective on the importance. So just to kind of speak to what my role, and I guess you could say what we're looking at, every one of these phishing attacks, well, first and foremost, I want to congratulate everyone. The email for the invite, you didn't get fooled. It wasn't a phishing attack, and you actually showed up. I know I constantly hear from my staff, or from all the office and even other components, I'll get the quick message, is this a spear phishing attack? Is this real? Is this legitimate? And I can appreciate the fact that they're sort of questioning and double thinking before they click some of these messages, but really, I almost want to say that you're not the audience we're worried about. It's the audience that we're asking you to go back and even spread the message even more. It's the people who may not pay as much of attention, the people that just might go through the day a little too quickly. I know we sort of do our own little internal surveys to the finding out the reasons of why did you click, what was the reason, what was the rationale, and really it's almost it's definitely more common than not that the reason people are going through or allowing potential access into the system, it's just because they're moving too quick, they're not paying attention, they're just trying to move through their day too quickly. And that's the importance. We're trying to get everyone in here, spread the word, just go throughout and just sort of show those best practices. As well, from the overall initiative, I know the other thing that we've done is stood up the website where we list out every single activity and sort of lessons learned and things to look for. I encourage everyone to keep going through that, even if you weren't sort of one of the victims or one of the individuals that actually got caught or clicked on it. Go through them, just sort of see what what potential gateways to getting into the system may be. I know most recently we're constantly trying to figure out ways, or from the meetings that we actually have, what are other things that we need to look at? What are things that we can do to best protect ourselves? And I think that's been apparent just from the past 2 or 3 exercises that were sent out. They were different than what had been sent out before. They had attachments, and they had another way that people were just not used to seeing. And it went to show, I think 3 or 4 exercises ago, there was a huge spike in the amount of people who were more or less putting CMS to risk. But as you could see that the learning curve kicked on pretty quickly because similar exercises were put out right after that. And just as I believe Emery said, there were just over 100 from the last exercise. So really, just in closing, I know that the data guardians, we're really no different than everyone else. We're just attending an extra meeting here or there, and we're kind of just spreading the wealth of knowledge to understanding what really staff need to do in order to protect ourselves and protect our systems, and to protect all of our beneficiaries' information. So with that being said, I know Karen, from OEI's perspective, you guys did a phenomenal job putting the whole event together. I don't think it could have been a better title than Respecting Privacy, Safeguarding Data, Enabling Trust. I mean, it hit it on the head. Celeste, and thank you all as well for attending.
Thanks, Jason, and thanks everyone for attending. And thanks to our speakers for coming. We really couldn't have done this without you.
You're live tweeting? Yeah, I am. I have a Twitter account, but I don't. She said a tweet about the thing. She did?